Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 25 of the Pennsylvania Case Law Update While You Drive podcast. My name is Katie McShane. I'm your host today, and today we'll be discussing cases decided between December 2nd, 2020 and December 8th, 2020. Another quiet week as we head into this holiday season. A few unremarkable cases this week, all of which can be found linked in the case notes. But the only case we will address in the podcast this week is Highlands School District versus Rittmeyer in the Tribune-Review. This is a case addressing access to public records and the contention between the school code and the right to know law. This case began when Rittmeyer learned through a public school board meeting that the Highlands School District has placed an employee on unpaid disciplinary leave. Rittmeyer submitted to a right to know law request seeking the employee's name, job title, length of employment, salary, and a statement of the charges that resulted in the disciplinary action. Rittmeyer was provided with the job title, length of employment, and salary, but no name and no statement of charges. He appealed to the Office of Open Records, which ordered Highlands to turn over the information. Highland argued that Section 708B78 excludes from disclosure records relating to an agency employee, including information regarding discipline, demotion, or discharge contained in a personnel file. However, the exemption does not apply to the final action of the agency that results in demotion or discharge. The Office of Open Records found that Highlands did not establish that the employee's name was exempt. Highlands appealed and the trial court reversed the order of the Open Records Office. The trial court noted that the exception precludes disclosure of information regarding discipline, demotion, or discharge contained in the personnel file, and observed that obviously an employee's name is contained in a personnel file. The trial court opined that to disclose the names of employees subject to discipline would thwart the purpose of confidentiality. The trial court further reasoned that the demotion or discharge provision did not apply, inasmuch as Highlands' decision to place the employees on unpaid leave was not a final action. Rittmeyer also argued that the provision of the school code provides that a detailed written notice with a statement of the charges upon which the proposed dismissal is based, prior to the hearing, conflicted with the right to know law, essentially overruling the exception. The trial court found that the school code requires a notice to go to the employee but does not conflict with the relevant portion of the right to know law because the contemplated action is not the final action to which Section 708B78 refers. The trial court ultimately concluded that Rittmeyer was not entitled to the names of the employees. Rittmeyer appealed to the Superior Court. The court first addresses when the right to know law is in conflict with another law. The right to know law expressly states that in the event of a conflict with another law concerning records, the right to know law shall not apply. Rittmeyer argues that the school code requires the disclosure of the identity in order to initiate the disciplinary process. It is in conflict with the right to know law, and therefore the right to know law does not apply. Highland continues to argue that the employee ID is exempt from disclosure under the right to know law. They further contend that because the school code allows for a private, meaning not available to the public, meeting if the purpose is to discuss any matter involving employment, appointment, termination of employment, and other areas related to employment, including disciplining of any specific current employee, that it is not in conflict with the right to know law, and therefore the names remain subject to the exemption. In coming to its conclusion, the Superior Court notes that the right to know law is remedial in nature and is designed to promote access to official government information in order to prohibit secrets, scrutinize the actions of public officials, and make public officials accountable for those actions. Consistent with the right to know law's goal of promoting government transparency, the exceptions to disclosure of public records must be narrowly construed. The primary focus of the Superior Court in this case is whether or not the school code is in conflict with the right to know law. In reviewing the school code, the court has held that a school board must resolve to demote the employee and to furnish him with a written statement of the charges prior to the hearing. However, the school code plainly contains no provision relating to public access to records. The code implicates the right to the employees to receive adequate process and does not pertain to any right of the public to access information about that employee. In fact, there is no language whatsoever mandating public disclosure of the identity of the employee. The court finds that the school code is not in conflict with the right to know law, and therefore the exception does apply. The court goes on to say that in the event that a final action resulting in demotion or discharge occurs, then the information would be subject to disclosure. Thank you once again for joining us. As always, we enjoy having you with us each week. I hope everyone out there is having a great and safe holiday season.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.